Welcome, everyone. We are recording this event via Teams. So for those of you who are in person, if you did not sign in, but you want to receive by email a copy of the video or a link to it, and also the slides, you can sign in where you came in. Those who are online, if you did not already use the registration form, but would like to get on that email list to receive the recording and slides, you can put your email address in the chat for this meeting, and we will capture it and send that to you. Welcome. My name is Barb Van Hoy. I am the Planning, Policy, and Engagement Coordinator for the City of Colorado Springs Housing and Homelessness Response Department. And it is my pleasure to be part of this really great collaboration in our community, working with organizations to provide renter rights education. So welcome to Renter Rights 101. And the partnership of organizations includes Colorado Legal Services, Pikes Library District, the Justice Center, Colorado Housing Connects, the Colorado Economic Defense Project, the Independent Center, Silver Key Senior Services, and the Area Agency on Aging. And I continue to be grateful for all the community partners working together on this. And some of those who are here will also spend a couple of minutes before we get into the main program telling you a little bit about all of the services and support that they offer. So after that, we will hear from Clinton Albert, attorney with Colorado Legal Services, who will give a real in-depth overview of the laws around renters and landlords in Colorado, including some information on new laws that have been passed by the state legislature in the past couple of years. Clinton may say this, it's a ton of information. So it's really helpful to have the videos and the slides, and he's going to go through it quickly. And I think I can say, he's going to be back in a second, that he prefers to, if you'll hold all your questions until the end, so he can get through the material before we go into questions. And just a reminder, he also cannot provide any legal advice for any issues that you might have. So if you've come saying, I have this situation and I need this or I need that, and can I do this or are they allowed to do that, that sort of thing, he's going to say, please apply for services through Colorado Legal Services. But if you have a general question that you can say, what are landlords allowed to do, or what are renters allowed to do, or that sort of thing, that's probably the best way if you have a specific question. As I mentioned, it's being recorded. We'll send these out. We'll also post them on the city's website. On our website under Renter Rights, we have a section where you can access all the videos that we've been doing and posting for the last few years. And so some of them were focused on things like habitability or lease basics. Recognizing that some of those were recorded before some of the new laws were passed, but those are resources as well. And I'll just say that in terms of resources that the city provides, for the most part, the city really does kind of coordination, and we decide how to invest some of the federal funds that the city receives with organizations that serve people, that help keep people housed, including some of the work that CEDP does, and also Colorado Legal Services. But we do maintain a webpage that's called Housing Help and Resources, and it is kept fairly well up to date. It's not all the resources, it's all the resources that the city has partnered with or works with, or we know that this is a legitimate place where you can get some help. And so that's one of the links that we'll share, and that's the resource that the City of Colorado Springs can provide. And so now I will introduce Elisa with Colorado Economic Defense Community. A lot of you, Community Economic Defense Project.
Thank you, Barb. Hi, everyone. My name is Alisa Rizzo. I'm here with Community Economic Defense Project, and I am the Senior Program and Operations Manager for our Colorado Springs office. And so the information I have for you today about our organization is around our rental assistance program. So we hold the Colorado Emergency Rental Assistance, and you can access that program if you are currently facing eviction and you have a summons or a demand. That is one of the key things that make you eligible for the program. If you would like more information, I will pass out these flyers. The other thing I want to mention is that we have a Stronger Together Housing Legal Day coming up. And as Barb mentioned, that Clinton cannot answer all questions specifically or regarding a specific case. However, at this event, there will be the opportunity to speak with lawyers who can answer those specific questions. So that event will happen August 29th, and I will also pass out flyers. And then we also have business cards with the address to our office. Some of the other work that we do is mainly around supporting people who are facing eviction. And then we also offer legal services. Community Economic Defense Project has CED Law partnered within it. However, our lawyers are located in Denver, but we are able to support folks facing eviction or specific warranty of habitability cases. If you are interested in accessing some of our services, you can visit our office.
Thank you. Yeah, do you want to go next?
Hi, everyone. My name is Deb Hamilton. I'm the law librarian here at the library. So if you're not aware, the library has a legal research collection at our downtown Penrose location, which is 20 North Cascade Avenue. So if you need to look up statutes or just need some help getting started with legal research, I can help you with that. I can also point you to community organizations that might be able to provide assistance that the library is unable to. I will put a link in the chat where you can find more information about our legal resources online. I also have my business cards on the table back here with a couple other flyers of upcoming legal programs in different topic areas. So please reach out if you need help after the session, or Clinton said something about this and I can't remember what the law was. We can always hook you up with the statutes and get you pointed in the right direction. So thanks for being here tonight.
Library. And I just met a new person with the Justice Center. I'm so glad Casey is here. Casey, you want to come up and just let folks know about what the Justice Center offers, and that you have those flyers. And Deb, if she hasn't already, we'll probably put the link in the chat for those online.
Thank you so much. I'm from the Justice Center. We are
Good to see you online.
Hi, guys. I'm Casey. I am from the Justice Center. We are a 501(c) nonprofit in town. We offer legal aid in a few different capacities. We have a phone-based hotline every Wednesday night. It starts at 7 p.m. It runs until 8:30. You can ask attorneys directly whatever questions you have, landlord tenant matters, family law matters. We also have an email program. We run that 365, 24/7. It's always online. And we also offer legal representation. That's going to be reduced cost or pro bono, depending on your situation, but you're welcome to apply. We have all the social medias. We have a YouTube channel with lots of helpful videos. We have little toolkits on our website. And I have more flyers over there, but I'll just go ahead and pass these little booklets around. Thank you guys so much.
Okay, I don't think we have, oh, yes, from Brothers. I almost forgot. Thank you, sorry. While she's coming up, for those of you who are online, I want to make sure you know there is a captions feature, that if you go up to the menu on Teams and click the three dots where it says more, and there's language options, and captions is something that you can do if you're like me and really like to have captions, even if it's in my language. And there should be simultaneous translation available, but I think it's still not the best. So just that FYI. Thank you.
Thank you. Okay, so I am with Colorado Housing Connects, also known as Brothers Redevelopment. We are specifically based out in Denver County, but we do help all over Colorado. So we will help with either Black Hills or Xcel Energy. So if you have any type of utility assistance, we can help with that. We do provide renters assistance resources, and we are open Monday through Friday. So if you need a call from 8 to 4:30, we are available for any type of resources you're needing, whether that's rental, legal service, utility, and then we also do a home preparation class each month. So if you're willing to looking into buying a home, we do have someone that will give you a certificate, and you can show that to the person who, if you're curious of buying a home with. We do aging in place, so we do home modification for seniors that are 65 and up. So if you have any type of home repairs, we go into your home and we assist. Coming up here in the summer, we have a paint-a-thon, and with that, we go to the 65 and up community and we paint their home inside or outside. So you can register online at our website for that as well. Um, any type of assistance with pretty much every question that you may think of, just call us. We're kind of like a 211. So just give us a call. And the number will be in the chat and someone will be able to direct you further. Thank you.
And I'm proud to say that the city provides some of our grant funds from HUD also to Brothers for some of those programs. So thank you. All right, now it's time for the main event. Unless there's another partner in the audience I haven't met yet. Great. Well, thank you, Clinton Albert. He has been working at Colorado Legal Services since 2018 with a caseload exclusively landlord tenant. So has been doing this a while. Thank you, Clinton.
Thanks, Barb.
Yep, that's right. You need to. Oh, I need to stop sharing.
Yeah, no, should. I think we're good. All right. Good evening, everybody. My name's Clinton Albert. I'm an attorney with Colorado Legal Services. I supervise the housing unit in the Colorado Springs office. This evening, we're going to be covering a wide variety of housing topics. If you have not already, put yourself on the registration list. If you're online, finish that. Why? We're not going to get through every slide tonight. There are too many. Also, in the spring sessions, the summer sessions at this point, some new laws have gone into effect in the last 8 weeks or so. So a lot of that up front is going to be covered. This summer, what has there are going to be additional laws that go into effect in August, that go into effect January 1, 2026. But this evening, we're going to have an extra focus on the new laws that are currently in effect. These laws touch on victims and survivors and additional protections that the law affords them when they are the victim and the survivor of gender-based violence. You're going to hear that term a lot tonight. That's going to be an umbrella term. What is covered by gender-based violence? We're going to cover it's going to be covering unlawful sexual behavior, stalking, domestic violence, and domestic abuse. All right. So if you hear gender-based violence, that's what we're discussing. It's a large umbrella for a lot of resilient folks to work through that. All right. So, let's see if this is going to cooperate with me. There we go. This presentation is informational purposes only. All right. I'm going to speed through things. I speak quickly. If I speak too quickly, please yell at me. All right. If you have a question, keep it till the end. I'm not calling on anybody's questions until we get to the end because I want to get through the material. All right. Why can't I give advice tonight in this open air setting with all of us listening and this being recorded? One, that's a bad place to give legal advice. And two, housing issues require a thoughtful analysis of both the facts and the law that apply to the case. So it's not something that I give a snap opinion on because there's investigation, there's research, and there's a thought process that goes into it. Also, if it's an important question, you probably want more than 3 seconds put into an important answer. So if you are a low-income member of the community, a senior citizen, and are facing a housing issue, you may contact Colorado Legal Services at that number, or in person at our office, or online at coloradolegalservices.org. All right, so new laws have been passed by the legislature. They have been signed by the governor. So like I said, some won't go into effect until January 2026. We're not talking about those tonight, all right? We're going to talk about the laws that are immediately that went into effect immediately, and also give a summary of some of the laws that are pretty related to this gender-based violence protections that will go into effect at the end, not the end, August 6th. All right, so it's another 2 months. And again, those will be noted on the slides as we're going through this. So there are new, like I mentioned, there are new expanded protections for victim survivors of gender-based violence. All right, what are the grounds for eviction? These are all, so as we're going through these are all through that lens. They're all through that perspective of the updates. This is not the complete list of grounds for an eviction. This is just the updates and the additions that are now being added under this protections for victim survivors of gender-based violence. So possible grounds for an eviction case are set forth in Colorado Statute 1340-104. There's a whole list of them. You can find it at the legal library and the library district. So one of the bigger changes here, and this is significant, is that they have added 2 words, contributed to. Why is that significant? So it is significant because if the gender-based violence contributed to the alleged unlawful detention, then the tenant's not guilty of unlawful detention. Unlawful detention, what does that mean? That's what a court has to find for a tenant to be evicted, that they are guilty of unlawful detention. So if previously, if gender-based violence was the cause of the alleged violation, then that would be a defense. But now that protection has expanded to contributed to. And if you're starting to think, well, how far does this go? We're going to touch on non-payment as well, because that's where this kind of really expands out to, is to non-payment cases and possible repayment plans. Okay, so like I just kind of explained here, it expands the defense for victim survivors from caused to contributed to. So this opens up more situations. Now, in order to, if you are a tenant and you have survived this, how do you provide that proof to your landlord so the law recognizes these protections? So have to provide proof of this to your landlord to place them on notice that you are a victim survivor of gender-based violence. What is that proof? Well, that's going to be a civil or criminal protection order. The criminal protection order that I am referring to is the 18-1-1001 protection order. That is a mandatory protection order that is issued in every criminal case. A civil protection order, that's the one that we are all familiar with, but the criminal protection order is a new form of proof. Another new form of proof to prove gender-based violence is going to be the self-attestation affidavit that states that the tenant is a victim survivor of gender-based violence and that the gender-based violence is the cause of, contributed to, or resulted in the alleged unlawful detention. This affidavit must also provide the name of the responsible party if it is known to the tenant and if the tenant determines it is safe to provide that name. Also, a qualified letter from a third party. You can see who are some third parties here. And the tenant sought assistance relating to the gender-based violence from that qualified third party. This third party letter must state that the third party believes that the gender-based violence occurred and was the cause of, contributed to, or resulted in the alleged unlawful detention. If a landlord receives conflicting information about the victim survivor status and whether or not there's gender-based violence, they may require that the tenant submit a letter signed by a qualified third party at that point. All right, so I kind of previewed here what the bigger protections are going to be, and this is related to non-payment cases. So Tenant cannot be evicted for non-payment of rent or other fees if the tenant agrees to a repayment plan and remains compliant with the payment plan if the non-payment was caused by or resulted from gender-based violence. All right. If you're like me, you're thinking a payment plan. Okay. What are the rules there? We're going to get to them. Just hear me out here. Okay. So landlords are still able to seek an eviction against the responsible party. So throughout this, if you hear responsible party, that's going to be the person who committed the gender-based violence. All right. Or is alleged to have committed the gender-based violence. When that's what we're responsible for, that GBV. Okay. If a landlord alleges non-payment and a tenant provides the landlord with documentation of that gender-based violence, and that documentation shows that the tenant is a victim survivor, then the landlord shall offer a repayment plan. Shall. This is not optional. This is mandatory. All right. And again, that proof is going to be what we just went through. This proof is going to be different than if you've watched prior presentations, like a text message for the warranty of habitability purposes. This has more requirements to it. An affidavit is a sworn statement by somebody. So that's going to be a little bit more than a text message. All right, so repayment plans. A landlord must offer a tenant who is a victim survivor of gender-based violence a repayment plan. Apologies for the typo. I missed that one. The repayment plan there are rules on the timeline here. All right. The repayment plan must be offered by the landlord no later than 3 business days after either serving the demand with knowledge that the tenant is a victim survivor or receiving that documentation from the tenant, that proof of gender-based violence, whichever date is later there. All right. That's when that 3 business days timeline comes into play. After the landlord makes this offer of a repayment plan, the tenant must take action within 7 days. That action is either going to be accepting the repayment plan or proposing an alternative repayment plan. This is an important step, and its importance will pop up here in a slide or two. All right. If the repayment plan is accepted, then either party must inform the court by motion that there was that repayment plan that was accepted, and then the court must not enter any judgments for possession or monetary damages during the pendency of that repayment plan. There is an exception here, but tonight we're doing broad strokes. If you're wondering, does this exception apply to my particular case? That's legal advice. That's where you're either going to want to apply with CLS or contact the Justice Center on a Wednesday night at 7 o'clock. If you are calling in for their call-in clinic, what I have been told is make sure that you are calling as that clock turns over to 7 p.m. because it is a popular number. All right. If you call at 6:59, you're not going to be waiting that extra minute. At 7 o'clock, the message switches over, right, Casey? Okay. All right. Still on repayment plans. So if a landlord does not offer a repayment plan, then that's a defense against an eviction. This law is in effect today, folks. All right. However, if you were offered a repayment plan and you do not accept it and you do not propose an alternative, then you lose that defense. All right. Repayment plans must be structured at the tenant's discretion. Here are the minimum requirements of a repayment plan. To pay the full repayment of all lawfully owed rent. Rent is the cost for the roof over your head. It is not another cost. It is not utilities. It is not common area maintenance fees, which are going to be prohibited January 1, 2026. It is rent. What does it cost to put a roof over your head? All right. Payments must be made on a monthly basis. They must be at a minimum $25. And at most, the plan can be 9 months. All right. That's the maximum length of a payment plan or a repayment plan. Landlords cannot charge fees for a repayment plan. All right. So if we're thinking through this non-payment situation as a victim survivor of gender-based violence, we've now gotten to the payment plan. What happens if there's non-compliance with the payment plan? All right. As a tenant, you're required to make the payments as you agreed to. If a payment is 10 days or more late, then the payment is considered untimely. And that is 10 days late by the terms of the payment plan. 7 days after the third or subsequent untimely payment, a landlord can serve a demand for all payments that remain lawfully owed under the repayment plan, requiring full payment before the next payment is due. That's a mouthful. So essentially what that means is after the third instance of an untimely payment in a repayment plan, your landlord can give you a demand after 7 days that says, hey, you need to get completely caught up with the plan before the next payment date. All right. If that full payment is not made before the next payment date in the repayment plan, then the tenant has failed to make payment. If the tenant fails to make payment before the due date of the next payment of the payment plan, then the landlord at that point may file a motion for judgment for possession. And a tenant may also assert any defenses for non-payment that may be applicable at that time. All right. So if there's a defect in the demand itself, that may be a defense. Warranty of habitability, other defenses may exist. All right. So if a tenant enters into a payment plan and then moves out and returns possession, the tenant's still entitled to that payment plan and any other statutory protections. And landlords can't pursue a money claim unless there's been that failure to comply with the payment plan, that failure to make payment. All right. So that's still kind of third or subsequent. That would apply if you enter into a payment plan and then move out and return possession. All right. What about substantial violations in gender-based violence? Well, the legislature stated that the victim survivor must not be unfairly penalized or suffer undue loss of housing as a result of gender-based violence. And there's no substantial violation. It's a defense against an eviction if the gender-based violence was the cause of, contributed to, or resulted in the alleged substantial violation. And landlords are able to evict the responsible party for the gender-based violence, which resulted in the substantial violation, just not the victim survivor. All right, so what about evictions? When serving a summons, if the landlord has that proof of being a victim survivor, then the landlord shall only personally serve the eviction summons on the victim survivor. What does this mean? It means that the responsible party is not going to be served there. All right, if they cohabitate. What about if there's been some kind of judgment that's been entered against the tenant who's a victim survivor? So if you find yourself in this situation, there's been an eviction and you miss the court, or you miss some kind of deadline as a result of the gender-based violence, then you can file a motion that you did not, and explain that you did not timely file an answer because you are a victim survivor, and did not receive or have a reasonable opportunity to respond, or you were otherwise unable to appear. Then the court shall relieve you from the final judgment, vacate any judgments, vacate any writs, and provide the tenant defendant with a reasonable amount of time to respond to the eviction, not less than 7 days. That would be consistent with the timeline on a summons. All right. Other reliefs. So this is kind of the hodgepodge slide. This is a weird one, but it's not weird. It's just kind of unique. With eviction cases, you're able to, as a tenant, you're able to file an answer, but the law says, hey, that's your answer. You filed it. You really don't get to file a new one that's set to amend it to say, hey, I've made some mistakes and here are some other things I may have forgotten. But if you are pleading gender-based violence defense, then you are able to submit additional amended pleadings to the court to support that defense. All right. Gender-based violence is also good cause to request a continuance, and the court shall make all reasonable efforts to schedule a trial date to accommodate any safety concerns. Be mindful of that last part there. The good cause is likely going to be for your safety, so that would be the reason for it. All right. There's also for writs of restitution. Typically, a writ of restitution is 10 days. If a tenant receives SSI, SSDI, or cash assistance through Colorado Works, then that goes to 30 days. Additionally, if a tenant who has asserted gender-based violence as a defense, if they are ultimately evicted, they would still get a 30-day writ of restitution, and the court would likely have to make that finding as well. Whoops. All right, so a little security deposit wrinkle here, and that's if the tenant provides documentation of that proof of gender-based violence and then terminates the lease due to the gender-based violence, then the victim survivor is not liable for any damage caused by the responsible party. All right. All right. So all of those were new additions. There has been a longstanding protection for survivors as a law. We're now going to start talking through how that's been expanded and the updates to the specific protections. The last few slides have just been really running through eviction additions. All right. So landlords shall not take any adverse action against a victim survivor, and leases can't waive the right to call police. They can't waive the right to call emergency assistance. Letters from qualified third parties can place landlords on notice of a tenant being a victim survivor. A tenant can terminate their tenancy by providing that self-attestation affidavit, the letter from qualified third party, police report, or civil or criminal protection order. It's the similar type of proof that we're just to establish that defense as well. All right, so landlord damages. Broadly speaking, when we are describing the protections for victim survivors and domestic violence, previously the main protection was if you provide your landlord with that proof, then you can terminate your lease without penalty, but you must provide you must pay 1 month rent within 30 days in order to be able to receive your security deposit. All right, got all that? Forget it. We're going to go through what the law is now. All right, because that's all kind of changed. Okay, so if a landlord incurs economic damages from a victim survivor tenant, right? And that's because if you're thinking, do you mean holes in the wall? No, that goes to the responsible party. What this really is more referring to is the economic damages. They were anticipating having a steady stream of rent income from this unit for X time, and that steady stream of income has been disrupted by the gender-based violence. So if a landlord incurs economic damages, then the landlord must submit documentation to the tenant within 30 days of termination, and such damages must not exceed 1 month rent. So it's now flipped. Before it required the tenant to pay 1 month rent, regardless. Now it's requiring the landlord to provide documentation of the damages not to exceed 1 month rent. Also, if there's another tenant that remains in the property, landlords shall not collect any economic damages from the victim survivor. Again, that's a departure from that's an update and a departure from what the law had previously been. If the victim survivor and the responsible party are both parties to the lease, then there is a legal presumption, meaning the law presumes that the victim survivor receives the full security deposit, less lawful deductions. Landlords must not deduct damages from victim survivors as a result of gender-based violence, and they have to assess those to the responsible party. Oops. If a landlord wants to pursue damages not to exceed 1 month's rent, then it shall provide a written statement of the actual damages from early termination within 30 days of the date of termination. If this is not done within 30 days, the right is forfeited. At the end of the presentation, sir, all questions are being held until then, so we can go through everything because I don't have to. That's your decision, sir. It's your time. I can't tell you if you're wasting it or not. We're going to cover a lot of items this morning, like I explained at the top. All questions are going to be held till the end. If you sign up for the registration, you'll get the full slides. We're not going to be able to get through all the slides tonight because there are about 160 of them. So I'm doing my best to go through everything. We focus at the front of this presentation on the legislative updates. So these are all new laws that have gone into effect in the last 8 weeks, sir. All right, so debt assignment. All right, so landlord shall not assign a debt by a victim survivor of gender-based violence to a third party. So debt collection, unless the landlord complies with the requirements of the law. But here's more of the nuanced here, and that's providing 90 days of written notice to the victim survivor expressing an intent to assign the debt. So you have to give the former tenant notice that, hey, I'm intending on sending this out. And that notice must be provided through the method of communication that the victim survivor requests or prefers. If there's no method marked, then the last known electronic contact information, which may be an email address. So shall not assign the debt if complies with the notice before the 90-day expiration period. And also landlord shall not disclose a tenant's status as a victim survivor unless that is required by court order, or unless or it's with the tenant's consent to sharing that status with the court in a civil action. So those are the two exceptions there. Rental applications. Not allowed to ask about the status at all in a rental application. Okay. Safety measures. So if a tenant provides documentation to a landlord of its status as a victim survivor of gender-based violence, then that allows the tenant to take some actions. Reasonable safety measures here. So they can change the lock, change electronic lock, install window bars, install cameras, install other non-permanent modifications to the home. It's not a material violation of the lease if the tenant does this. After providing notice. If the locks are changed, then tenants are supposed to are supposed to provide the landlord with a copy of the key or the code as soon as practicable and no later than 14 days after changing. However, if it's the landlord, if it's the property manager or the owner that is the responsible party for the gender-based violence, then the tenant shall make reasonable efforts to provide the key or the code to another person who has the authority to manage the property and determines that that other person is safe, so long as that other person agrees not to share the key or code with the responsible party. What happens if a landlord does not comply with these new laws? A tenant may bring a civil action for a violation of this section. If the court finds a violation, then it's going to award actual damages and 3 months rent or $5,000, whichever is greater, as well as any punitive damages the court deems appropriate. Other damages as appropriate, attorney fees and costs. So those are all the laws that are in effect now. Here's what goes into effect August 6th. Demands for unpaid rent must include a statement that if the tenant has experienced gender-based violence that has caused the tenant to miss rent payments, then the tenant may provide documentation to the landlord and the tenant is entitled to a payment plan that allows repayment of unpaid rent over a period of time not to exceed 9 months. If a landlord is serving a notice to terminate or a demand for compliance and are attempting to serve a victim survivor, this is an additional protection. There must be 3 attempts at personal service before that can be posted to the premises. If you're thinking, what are other folks getting? It's 2 attempts. So there's an additional attempt. Those attempts are on separate days as well. It's not just going to the door, knocking, waiting 5 minutes, knocking a second time, waiting 5 minutes, knocking a third time. Separate attempts on separate days. So the status as a victim survivor, again, this goes into effect August 6th. If a tenant discloses that to the landlord and consents to it being shared, then the landlord shall disclose that status to the court in either the complaint or in the return of service. Record suppression. So this goes into effect on August 6th, but it can reach back in time. All right. So what does this new kind of protection allow? So if a victim survivor may file a motion to suppress prior records or to keep records suppressed, even if those records predate August 6th, if the tenant provides the proof of gender-based violence and asserts that the public access to these records poses a risk to the safety of the victim survivor or to a family member. A summons as of August 6th must also contain a bold-faced statement that if the tenant was a victim survivor of gender-based violence, and that was the cause of, contributed to, or resulted in the lease violation, then a defense may exist and may be entitled to a repayment plan. The summons also must contain information on how to enroll in the address confidentiality program. The right to cure now includes a repayment plan. So if you're thinking, how does that really come into effect? That comes into effect in where there have been, the tenant has failed to make payment after 3 untimely payments, and the landlord has filed the motion for entry of judgment for possession. So that right to cure, it's going to be in Colorado Revised Statute 1340-115, now extends to repayment plans. All right, those are the new laws. Now, moving on to kind of the lifespan of the tenancy. Like I said, I'm going to be with the time crunch here. Oh, great. Way ahead of schedule. It's only 6:15. Perfect. I'm going to do my best to wrap up the presentation at 7 o'clock to open it up to questions then for the last half hour, because they are pretty tight on time. And I don't want the lights turned off on us again. So if we think about the rest of the presentation as kind of the lifespan of a tenancy, this is, we're at the beginning of this. So before you're moving into the new home, the new apartment, whatever it may be, put everything in writing. That's the best practice. All right. This is a contract. This is a business relationship. Oral leases are valid. They're not going to have specific terms. It's going to be hard to prove anything other than this is what we agreed on the monthly rent. So the best practice is really to have a written agreement. Applying for a residence is, so this is covered by the Rental Application Fairness Act. Here are the areas of what the rental application fairness can look at. Income requirements is a maximum of 200%. You can ask about, landlords can ask about income for determining eligibility for income restricted properties. There's no consideration of credit history that's older than 7 years. And for criminal history, no arrests can be considered. Convictions older than 5 years are not to be considered, except generally speaking, methamphetamine related offenses, offenses which require a person to register as a sex offender, homicide related offenses, and stalking. If a landlord does not follow the Rental Application Fairness Act, then a applicant may file a lawsuit. The possible penalties there are going to be 3 times the amount of the application fee, court costs, attorney fees, a $50 penalty for certain violations, and then if those certain violations are not fixed, that $50 jumps up to $2,500. When we are in the application section, a portable tenant screening report is, well, it's a consumer report that a tenant, an applicant can obtain and then provide that to prospective landlords. Providing that to prospective landlords then eliminates that application fee because that cuts out the cost of a background check. These must be accepted by landlords. They can require certain updates or statements related to them. So the report includes name, contact information, verification of employment, income, last known address, rental, credit, criminal conviction history for each jurisdiction indicated in the report as a prior residence. So landlords are required to accept the report. They may require that the report be completed within the prior 30 days, that it be made directly available to them by the reporting agency or through a third-party website, that it be made available at no cost to the landlord or access or use in the application, or a statement from the applicant that there's not been any material changes to the report since it was created. Landlords are not able to charge a fee to access or use a portable screening report in an application. They must also advise applicants that they have a right to use a screening report, cannot charge an application fee when using a screening report, and cannot charge a fee to use a screening report. So this advisement, it's got to be located and delivered in a manner likely to reach the applicant. So website, advertisement for the property, online advertisements, and or orally to the applicant, followed up by a written confirmation. That seems pretty cumbersome. So best practice would just be put it on a website or put it on the advertisement for the property. There are certain exemptions from portable screening reports. So landlords don't have to accept portable screening reports if it only accepts one application at a time and refunds the total application fee to each applicant within 20 days of declining the application. I don't know where that system is up and running. I'm unfamiliar with any type of, I've never seen that, but I suppose it's possible. If a landlord obtains a consumer report on its own, it shall provide the tenant with a copy of that report, and the copy must also include an advisement of the right to dispute accuracy with the reporting agency. And then if a landlord denies an application, it must be in writing, 20 calendar days to provide that written notice of the decision to deny. All right, but in this scenario, application's been approved. Lease is put in front of us. They're saying just sign it. Read it. I don't care if it's 100 pages. I know it's going to be. I know it's going to have 18 addendums too. It's going to be real confusing. But guess what's not a legal defense? I didn't read it. If you sign it, you are saying, I have read it. I agree with the terms. Read it. Take your time. This is a legally binding contract for a year-long period. Probably want to know what you're signing up for the next year, right? You want to see what is the length of this, month to month, year to year, rollover provision. What are potential fees here? What about responsibilities for upkeep, maintenance of the property? Where do you need to send notices if there's an electronic notice? What are any other house rules for the property? What about if it's an exempt residential agreement? And again, where do you send warranty of habitability notices? What about appliances? Right? And that's going to include not just refrigerators, kitchen stoves, but also what about air conditioners, portable cooling devices? An exempt residential agreement, this is going to be single family residences where the landlord owns fewer than 5 single family rental homes, and it says it in the written lease agreement. Really what this means is that a tenant has 5 days for a demand for compliance instead of 10. Just generally speaking, if we're kind of in an option to purchase, or rent to own, I'd really recommend seeking a second opinion before going into that. And why am I saying that? Because a lot of those options or purchase options have a large upfront payment. So you want to see if you gain any equity with that payment and what happens to that in the course of it if you ultimately don't go through with the purchase. Also, when do you have to exercise the option? All right, because it's pretty devastating to talk to folks where they've been living in a place for about a decade. They think they're on track to own it, but they never exercised the option, and that expired 8 years ago. So they really don't have any equity. All right. All right, so we've got the lease. We're reading through it. These are lease provisions which cannot be enforced. Your lease cannot waive the right to the return of a security deposit, barring a separate written agreement. Cannot waive your right to the warranty of habitability, barring a separate written agreement. Cannot waive your right to the covenant of quiet enjoyment, written demand for unpaid rent, court process for evictions, late fees that are greater than $50 or 5% of late rent, unreasonable liquidated damages that assign a cost stemming from an eviction action or notice, one-way fee shifting attorney fee clauses, the right to a jury trial except can waive a jury trial for possession, ability to join a joint action, class action, collective action, the implied covenant of good faith and fair dealing, covenant of quiet enjoyment, implied covenant of quiet enjoyment, any fee for not providing a notice of non-renewal for the end of the lease, a provision that characterizes any fees for utilities or services and any other charge that is not the monthly payment for occupancy of the premises. Rent is rent. You can't say that utilities are rent. Utilities are utilities. Provision which requires the tenant to pay a fee markup for a service for which the landlord is billed by a third party, can charge a fee no greater than 2% of the actual cost or up to $10 per month, but not both. Also, a voucher or subsidy provider cannot evict for non-payment of utilities. So those release clauses that cannot be enforced. I really hope no one's trying to write everything down. Again, there's way too much to write down. Register, get the slides. All right. So what are lease clauses that are required to be included? One of them is that they must include a statement regarding income discrimination in Colorado, and it prohibits that and requires landlords to accept any lawful and verifiable source of money. This required lease clause does not apply to landlords with 5 or few single-family rental homes and no more than 5 total rental units, including any single-family rental homes. So you're renting by bedrooms and it's more than 5, that's going to apply. All right, you've read through it. We know what we're signing up for. Get a copy of it. You want that copy if there's ever a dispute. All right. The law also requires that your landlord provide you with a copy of that within 7 days. Okay, so what happens if throughout the course of this lease, your tenancy, your landlord changes, or the building sold? Okay, those are two kind of different scenarios here. Landlord changes, but the ownership remains the same. Nothing's really going to change. Okay, the new management must provide you with updated contact information to include new address or addresses for notice. If this doesn't happen, contact your landlord to say, hey, where do I put you on notice? Where do I send notices? Do you have to do that as a tenant? No, but that's best practice. If your heat goes out in January, you want to know who you need to contact. All right. Also, if it's just change in management, that does not affect the terms of your lease. The new management kind of assumes the contracts that the prior management has. Okay, that's when management changes. But if the building is for sale and your tenancy is jeopardized, that could be a number of different things. All right, but let's say you have one option to try to make sure that your tenancy is not jeopardized is to take your lease to the clerk and recorder and file it. All right. That places any potential buyer on notice that you have a contract and you have the right to possess the property. All right. Because if the buyer doesn't know about it and is a good faith buyer, then that could have the potential to cancel a lease. Consult prior legal advice to doing this. If there's no current lease agreement, or if it's a verbal lease agreement, then there's nothing that's going to be filed with the clerk and recorder. So you may, at that point, that's where you may want to contact the new owner to propose a new rental agreement. Rent increases. One time, 12 months. Excuse me, sorry. One time within a 12-month period of consecutive occupancy, and it must contain 60 days written notice. May not terminate a tenancy with no written agreement by serving a notice to quit to try to circumvent the 60-day notice requirement. That probably isn't as likely anymore as the no fault eviction statutes, which require a 90-day notice for a lot of causes, but we'll get to that a little bit later throughout this presentation. Late fees. All right, big thing is, all right, late fees cannot exceed $50 or 5% of the rent. They cannot be charged unless a rent payment is 7 calendar days late. So when you're reading through your lease agreement, see which day your rent is due. It's 7 days after that is the first day you can be charged late fees. Also, late fees must be disclosed in the rental agreement. All right, can't evict a tenant for non-payment of late fees. Can't terminate a tenancy for non-payment of late fees. Can't impose a late fee for a voucher or subsidy provider having a late payment for their share. Can't have more than one late fee unless those smaller late fees are still under $50 or 5%. Can't require interest on a late fee, and can't charge a late fee unless you provide written notice of the late fee within 180 days after the date upon which the rent payment was due. Why am I speed reading through this? Because we still have over 100 slides. It's an affirmative defense. So a violation of late fees can be an affirmative defense. Late fees, as distinct from rent in a rental agreement, may not classify a late fee as rent for the purposes of an eviction statute. Also, you cannot apply a rent payment to the non-payment of late fees or to late fees, period. A lease provision that does not comply with the statute is void and unenforceable, and a tenant may bring injunctive relief. A landlord who violates the statute shall pay to the tenant a penalty of $50 per violation, not per late fee, per violation. One late fee can violate it in a number of different ways. A landlord who violates the statute has 7 days to cure the violation, and that time begins when the landlord receives written or electronic notice of the violation of the illegal late fee. If the landlord violates the late fee statute and then does not fix the problem within that 7-day period, the tenant may file a lawsuit seeking damages and a penalty of $50 to $1,000 per violation payable to the tenant, costs, attorney fees, and other equitable relief the court would find appropriate. All right, we've signed the lease. Truck's out front, car's out front. All our friends are waiting to unpack all our stuff. Before a box hits the ground, do a walkthrough if you haven't done one already. Even if you've already done one with the landlord, with the property manager, go do another one before you put anything in your house, right? Why are we doing this? You want to document the condition of your residence at the beginning of your tenancy. Take pictures of everything. Take videos of things to show the water pressure if there is an issue, to show that something doesn't really shut fully. All right. If it's damaged, if it's undamaged, document it. Why? This is going to be your proof at the conclusion of your tenancy. If you're saying, no, that was like this when I moved in, and you can see, here's the photo that I took on June 10th, 2025, which shows you that same paint mark on the wall. All right. Do a walkthrough. All right. Again, you don't have to do this with your landlord, and it's not required. But if it's possible, I think that's a good starting point. You walk through together, you look at things together. If there are issues, you point them out together. All right. Then after that, that way, both of you are entering into the lease with the same understanding. Hey, this is what, there are some issues here. Here are the issues that are going to be taken care of. Best practice would then be follow up on that walkthrough with an email saying, here are the issues we identified. When will they be repaired? Be critical. Don't be unreasonable. You're not being a bother by pointing things out, right? You're paying money for a habitable place to live. This is a business. They're not doing you a favor. They're taking your money. Yeah, it's business. Okay. And it's better for both parties to have, to me, it always seems that it's better for both parties to have the same understanding of this is what's going on at the beginning. All right. All right. Now we're in the house. What are things that pop up? Well, the warranty of habitability is the big one, right? And that is the promise that your residence is fit for a human being to live in. There are a list of things that must be present. If you've been at prior, here's the list. Okay. Don't write them down. Get the slide. Look at it. Okay. Here's the process for bed bugs. Okay. With bed bugs, if a landlord has received notice of that, they have 96 hours to obtain a qualified inspection from a qualified inspector. What does that mean? That doesn't mean you go down to ACE, you get a few buggy boos or something, and you go and you throw down traps. No, unless your side business as a landlord is also pest extermination. All right, because there's that little detail there about qualified inspector. Qualified, meaning you're qualified to do this. You know what you are doing. I don't. I'm not a qualified inspector. Landlord may enter that, your residence, and also any other that it's connected to for the purpose of an inspection. If an inspection confirms bed bugs, then inspect for all contiguous units as promptly as is reasonably practical. Another point here, the cost of inspection and the cost of treatment is the landlord's responsibility. That, as a tenant, that is not your responsibility. However, you are responsible for getting the place ready. So if you have to go buy Tupperware tubs to throw all the dishware in, that's your cost. If you have to buy trash bags to bag up all of your clothing, that's your cost. If you have to go run all of your clothing through a laundromat on high water temps, that's your cost. It's not fun. I understand this. Again, more bed bug process here. Sorry, folks, I'm just seeing where we're at on time because I don't want to spend an enormous amount of time here. As a tenant, if you put your landlord on notice and then you don't allow the inspection to happen or you don't allow the treatment to happen, then your landlord can take you to court to force that to happen. And then you could be responsible for your landlord's damages and also the cost of inspection of treatment for all the units. So let the bug people in. Also, if you're looking at a place and you want to know, hey, when's the last time this contained bed bugs, you can ask the landlord, and they are required to disclose to their knowledge if it contained it in the last 8 months or the last date it was inspected for and found to be free of bed bugs. Again, here you can see that if a court finds the tenant has unreasonably failed to comply, the court may issue an order granting access, the right to inspect and treat, and requiring the tenant to comply with specific inspection and treatment measures or assessing the costs and damages related to the noncompliance. Again, this is another condition for the warranty of habitability. That's the section that we're in here. Here is the process for mold. All right, or this is the definition of mold. I'm not going through the process this evening. There's a specific process. If you're worried that it applies to you, first step is always going to be a written notice to your landlord. All right, that written notice can take a number of forms that we'll go through in a little bit. Appliances. These are the appliances. Also, a condition that materially interferes with life, health, or safety. Previously, this was a little bit more subjective. Now, we have a little bit more guidance from the legislature, as if these conditions are present, a court is going to presume that a property materially interferes with a tenant's life, health, or safety. So what do these conditions entail? These all are going to be similar to the prior conditions that were just listed on the slide, but given the seriousness of them, that they're going to materially interfere with life, health, or safety, they require a response within 24 hours, as opposed to 96 hours or 72 hours. I'm sorry, but it's 24 hours for these. Any kind of lack of waterproofing and weather protection. There were pictures on this, I swear. Essentially, if the walls, if the windows, if the doors can let weather in, right? If you're thinking, what does that look like? It looks like having a hole in your roof and it just raining inside. Hazardous conditions of gas piping, facilities, appliances, or other gas equipment. Inadequate running water or inadequate running hot water. There's an exemption there for temporary disruptions. Okay. This happened to me 3 months ago, so I apologize again. I promise there were pictures on all these slides to make it fun and exciting. But if there's a lack of heat between October and April, that's going to raise that rebuttable, that presumption that, hey, this is going to materially interfere with life, health, or safety. It's a presumption, which means that it can be rebutted. How could that happen? Well, think about one of those 75-degree days we had in March that were absolutely delightful. If you don't have heat on a 75-degree day, the court's not going to find that. That's going to be evidence that, hey, there was not actually a condition that materially interfered with life, health, or safety that day. Hazardous conditions of electrical wiring, facilities, appliances, or equipment. Lack of electricity or disruptions that are caused by landlord's failure to maintain wiring, facilities, appliances, equipment. Infestation. Inaccessible fire exits or egress in accordance with applicable building, housing, fire, and health codes. That makes sense, because if you can't get out of a fire escape, then kind of are living in a trap, and that's not good. I am so sorry, folks. I promise there were slides on this 2 hours ago when I was doing my final read through. If the chimney system or any venting or fuel-fired ventilation, heating, cooling system is damaged or misaligned, that's a problem. If the elevator is inoperable and the tenant has a disability that prevents the tenant from being able to use the stairs or relies on the elevator to access the dwelling, and there are no other operable elevators, yeah, that's a problem. You're trapped then. That's a cell. Landlord can rebut this presumption, right? They can say, no, this actually didn't materially interfere with life, health, or safety, by demonstrating clear and convincing evidence that it did not. My fallback example is the beautiful spring day where it's 75 degrees and the heat's out. All right, so when does a breach happen? It's not just because the condition exists. So that does have to be there, but the breach happens after the landlord has received a reasonably complete notice of the condition, and then they failed to commence remedial action by employing reasonable efforts within the required times. That's a mouthful. What does that mean? They got the notice, they didn't start fixing the problem, right? So, timelines that we talked about: life, health, or safety, 24 hours. Uninhabitable by statute, that long list that we didn't really spend any time on, 96 hours. Mold. Here's the mold timeline. So generally speaking, 96 hours for the first section of it, okay? You can see kind of the timeline here, but still have another 80 slides to go. So let's keep moving, folks. All right, after we give that notice to our landlord, do they have to respond? Yes, they do. In short order, yes. Within 24 hours of having received a reasonably complete notice, a landlord must respond to that notice. What does that respond? There's also an exception here that 24 hours can go up to 72 hours if the premises can't be reached due to an environmental public health event, fires, floods, mudslides, things of that nature. What does this response must contain? How I'm going to fix it, when it's going to start, when it's going to finish. Proof of filing an insurance claim is not proof of anything for the purpose of the warranty of habitability. What about an alternative residence? Yes, there are requirements to provide that. If the residence is in a condition that materially interferes with your life, health, or safety, and you make a request, then the landlord must provide a comparable dwelling unit or a hotel room as selected by the landlord at no expense or cost to you. I need to. This slide's incorrect. I very much apologize. The landlord is responsible for costs that can include transportation and also possible per diems. We will get to that slide in a little bit. I'm just going to go through this. I'm skipping that now. All right. If the landlord breaches the warranty of habitability, the tenant can terminate the lease, can obtain a restraining order or rejective relief, which requires the repairs to be made. If you're hearing restraining order and you're thinking that's weird, the restraining order from a legal theory, it's to tell a person you are violating the law. You are to stop violating the law. In this case, landlord, you have breached the warranty of habitability. You are not following the law. You must follow the law. So that's if you're just kind of on just a very foundational level, that's kind of the purpose of a restraining order. It's not the same restraining order if you're thinking of kind of commonly under Chapter 14 for domestic violence or domestic abuse. Can also defend against an eviction for non-payment of rent. Can defend against an eviction for other reasons as well. You can withhold rent too. Would recommend seeking legal advice before taking this step. You want to make sure that the notice is perfected. This doesn't have the same type of risk involved in it as it previously did because you have the right to cure up until a court enters a judgment for possession. Deducting the cost of repairs is an incredibly specific process. It doesn't apply to everyone. It doesn't apply to every condition. You can't, you have to provide estimates. The estimates have to come from a licensed professional that you are not related to. So just generally speaking, I'd seek advice before taking this step as well. Because there are pretty big penalties, pretty serious penalties if it's done wrong. If there's a bad faith deduction, then it's an automatic eviction and then a money judgment for 2 times the amount withheld. There are exceptions to the warranty of habitability. That's where there's a written agreement that's separate from the lease agreement that's signed by both parties and it's supported by adequate consideration. Not thought process, but some kind of money or payment in kind, right? You know, in exchange for maintaining, if we have an electrician and they enter into a lease agreement, then they're chatting about it and the electrician goes, hey, you know, I can handle the electric here if you want to knock $100 off my rent a month. Landlord says, great, that gets put in writing. Then the tenant is responsible for the electrical. And that would not be a basis for the breach of warranty of habitability. But one of the requirements there, I kept saying, you know, electrician specifically, because you have to have the skills to perform the work. If you're unsure about whether this situation would apply to you, that's where I'd seek legal advice. All right, the warranty of habitability at a trial. So we're now into an eviction. If it is raised as a defense and the court rules in favor of the tenant. Excuse me. The court shall determine the reduction of a premise's rental value in its uninhabitable state to the date of that trial. They're going to deem the tenant the prevailing party, meaning they win. Then the court has to, the tenant has to pay rent that has accrued to the date of the trial, taking the reduction of value into consideration. Must be made within 14 days. If not, then the court reverses its order and awards possession to the landlord. Also, a breach of the warranty of habitability is also a defense against a collection action. Court may also order the landlord to make repairs and correct the uninhabitable conditions. Shall order that the monthly rent be limited to that reduced amount until the repairs are completed. So the court then maintains jurisdiction. Retaliation. So any landlords are not able to retaliate against the tenant for making a good faith complaint. So here are ways that, you know, different categories of retaliation. One of the bigger changes here in the last year, and I think retaliation is difficult to prove because we're talking about what's inside somebody's head, right? So it's not just that it was the only factor, but that the protected activity was a motivating factor that influenced the landlord's decision to engage in retaliatory action. So it's not the same level of absolute proof that was once required. Here are some resources if we're dealing with the warranty of habitability issues. Code enforcement. I throw this in here just because code enforcement's role is to enforce the city code. Okay. And if you're thinking, thanks, Captain Obvious, you took code enforcement and then just switched it to enforcement code. Yeah. So their role is not for the warranty of habitability. There are also gaps between the two. For example, city code requires screens on windows and has nothing about mold. The warranty of habitability does not require screens on windows and has an entire section and process for mold. All right, so it's not a direct one-to-one, but a code enforcement report can also double as a notice for the purposes of warranty of habitability, which we'll get to after our no-fault eviction section here. So document that was previously referred to, all right, as a notice to quit, now a notice to terminate tenancy. There are limited reasons that a landlord can terminate a tenancy now, but that's if the law applies to them. It doesn't apply to everybody. So it doesn't apply to short-term rentals, doesn't apply to employer-provided housing, doesn't apply to mobile home tenants with equity in the home, whether they are the owner, they have an option to purchase, a lease to purchase, etc. Tenancies where it's been less than 12 months, so less than a year. Tenants not known to the landlord to be a residential tenant. If you're thinking squatter, please, I don't think this is what that means. Okay, their unauthorized occupants have their own laws, its own section, 24-hour notice, 24 hours till a court date, 24-hour writ. There are not squatters' rights. Stop it. Okay, so, but what I like to think of when I see not known to be a residential tenant, okay, that's the key word there. So think about a small business owner trying to, scrape a business off the ground and they're sleeping in their office because they're working 22 hours a day type deal. That's where it's not known to be a residential tenant, known to be a commercial tenant, but not residential. All right, so this wouldn't apply there. A property where the owner or quote unquote master tenant lives in the premises and the premises is less than 4 dwelling units, whether that's a single family residence, duplex, triplex. A property where the owner lives in a property adjacent to the residential premises and the premises or adjacent property is less than 4 dwelling units. These are where it does not apply. So what does this change mean to applicable tenancies? With the notice to quit, didn't need any reason at all, so long as it was within the bounds of the law and fair housing. And there were different notice periods based on different lengths of tenancies. With the notice to terminate tenancy, the reason is required. It must be stated in the notice. 90 days of written notice are required. So here are the reasons that we can terminate a tenancy. I'm going to go through it because we're going to go through each one. If this is demolition or conversion of a residential premises, they're demolishing or converting to non-residential use or short-term rental use. 90 days written notice, including a description and timeline of the demolition/conversion project and a material demonstration of the proposed date when that project will commence. That means building permits, application for permits, or license to operate a short-term rental. Tenants are allowed to remain in possession throughout this 90-day period. Same terms and conditions. Substantial repairs or renovations. So if a landlord plans to make substantial repairs or renovations, it may terminate a tenancy with that 90-day notice. Provide the tenant with an expected completed date and a general description of the repairs and renovations. Proceeds without unreasonable delay to begin the repairs or renovations after regaining possession. And there's somewhat of a right of first refusal here. If the work is expected to last less than 180 days, the landlord shall provide the tenant with a notice, including the expected completion date, right? If the tenant then responds within 10 days that they would like to return to the premises, the landlord shall offer them the first right of refusal to sign a new rental agreement within reasonable terms. If that new agreement is accepted, tenant has 30 days to occupy the premises unless the parties agree on an extended timeline in writing. This doesn't apply if this theory doesn't apply if the repairs are required to make a property habitable. It's not a kind of workaround for the warranty of habitability. Or if the repairs are initiated in retaliation. Another reason here is if a family member or family landlord or family member of the landlord wants to move into the property. Again, this is able to do if if they move into the property within 3 months after the tenant moves out, provides 90-day notice to the tenant. There's no substantially equivalent unit that is vacant and available for occupancy by the landlord or landlord's family member in the same building. And the landlord does not list the property for long or short-term rental for at least 90 days after the date the tenant's required to vacate. 2 exceptions here. It's active duty military or active duty military spouse. It's a 45-day notice. That 90-day notice can be extended to accommodate the property for a disabled family member or landlord. So if we're thinking about that 90-day move-in period after the fact, that can be extended to accommodate additional repairs. Selling, we're pulling the property off the rental market and selling it. 90-day written notice, serves the notice, does not list the premises for long or short-term rental for 90 days after the move-out date. This does not mean you can terminate a rental agreement early. This is all at the end of a rental agreement, okay? Tenant refuses to sign a new lease with reasonable terms. Again, 90-day written notice after the tenant's refusal to sign the new lease agreement and properly serves the 90-day written notice upon the tenant. Landlord shall not increase the rent in a discriminatory, retaliatory, or unconscionable manner to get around the new law and force a refusal to sign. History of non-payment of rent. All right. 2 times during a rental agreement, if the rent payment is late. What does it mean for the rent payment to be late, folks? All right. It's not that it wasn't paid on the 1st. It's if it is submitted more than 10 calendar days after the day it is due, according to the rental agreement, and provides the tenant with a proper service of a written notice, written demand. And if there's a payment made during the cure period, it's not late. All right, use your imagination. I promise you I did this afternoon. The first page of the notice to terminate was over here. Stupid PowerPoint. Making me seem more incompetent than I already am. All right, so this is the JDF form. It's JDF 99B. So if you want to see what it looks like, you can just search that one. All right. If you look, JDF Colorado self-help form, some kind of search under that, you'll be able to find a lot of these forms. So this is the written notice to terminate for one of those limited reasons. All right. Those reasons we just went through. Those are the reasons. Okay. It can't be outside of that. All right. So the written notice must include a statement of the legal and factual basis for the no fault notice to terminate tenancy. What does that mean? It has to describe what happened, because I think about it on, I think about the history of late payments, right? You have to say these are the dates that the payment was made late. Okay. Well, because then you have to put the tenant on notice of these are the reasons that you're being evicted. So you can defend against them. So you can mount a defense. You can say, no, that's not accurate. I made the payment on whatever day within the cure period. Here is my receipt. This is not a late payment. The notice also must include a mediation advisement. Also, must include a specific description of the alleged no-fault grounds. Alleged grounds. That does not mean that they specifically describe what the statute says. That's what the law already says. They have to specifically describe why they are saying what you did or didn't do as a tenant is why they are terminating the tenancy. Also, it has to be in a language that the landlord knows or has reason to know is the primary language of the tenant. Cannot waive or modify any part of these reasons in a written rental agreement. Any attempt to do so is going to be void and unenforceable. If a landlord proceeds with an eviction for a reason that's outside of these and the law applies and the tenant loses possession without a court order, they may pursue a claim for an unlawful eviction. Not following these procedures is a defense against an eviction and can be raised by a tenant as a defense against an eviction based upon the termination of tenancy for the alleged reason. All right. It's going to be really speedy time here, folks. Unlawful detention, like I said earlier, that's what a landlord must prove. Lease violations other than non-payment and substantial violations must be a material condition or covenant to the agreement. Materials, that's as much of a definition as we have. Material condition or covenant of the agreement. Gonna have to wait for case law to really flesh out what that means. So if you're thinking, well, is this part of my lease material? My answer is 1, That's legal advice. And 2, I'm gonna have to take a look at things, so probably don't know right now. All right. Quiet enjoyment / nuisance. This is a new basis for eviction, and that's if the tenant has disturbed others or caused a nuisance, and that disturbance / nuisance interfered with the quiet enjoyment of the landlord, others who reside in an immediately adjacent property, or other tenants or occupants of the same property. The landlord must live in the same property or the next door property for that to apply to the landlord, right? If they live in Virginia, it's not going to apply. If the tenant has negligently damaged the housing accommodation, a demand provided under this section, this legal theory of nuisance, must provide an opportunity to cure, say, hey, you have to stop this behavior, and must also contain a description of the specific conduct that disturbed others. Because if you're giving a demand saying, hey, you have to comply, you have to say what you have to stop doing. Oh, it's not fair. There are exceptions here. Tenant's lawful exercise of its right pursuant to any law or rule relating to the occupancy of the property is not a nuisance. And also, as no surprise here, after the first half hour, 40 minutes of me rambling, and that's that if the person is a victim survivor of gender-based violence, that is not going to create a nuisance. So demand for compliance must include the following: a specific description of the alleged violation. So we're now out of those notices, those 90-day notice to terminate tenancies. We're now into demands. We're in the middle of the lease. We messed up somewhere along the lines. So, but the demand has to tell us what that was. It has to also state the date and time when the premises must be given back. Must be in a language that the landlord knows or has reason to know is your primary language. Serving a demand. Gosh, just deleted all my photos of this. I'm so that, all right. Has to be served on a known tenant occupying the premises with some person above the age of 15. You can serve by posting, but like we talked about, you have to attempt personal service first. So on two attempts on separate days. So day 1, day 2, at that point, it can be posted. All right, security deposits cannot be greater than 2 months. Why did that photo show up? All right, so briefly on security deposits here. They can be kept for damage beyond normal wear and tear, non-payment of rent, if abandonment of the residence, non-payment of utilities, repair work, cleaning work contracted for the unit by you as the tenant. What's normal wear and tear? That's the usual deterioration which occurs when living in a residence. You have carpet, guess what? The carpet around the front door, it's going to get worn down a lot sooner than the carpet in the back corner where you never go. That's foot traffic. That would be expected. What is not normal wear and tear? Careless or intentional destruction of property. You punch a hole in the wall, you're going to pay for that. So what should you do when you move out of the residence? All right, we're hitting the end. So if we think back to what did we do at the beginning? Well, first we clean the residence. Yep, you got it. We're going to do another walkthrough if we can. We're going to take this, we're going to go through our photographs that we took at the beginning of when we moved in, and we're going to go and we're going to take those same photographs again. All right, because now we have a beginning set, now we have an end set. We're also going to return the keys and we're going to provide a forwarding address. Returning the keys is very important. That's a big kind of fact that a court will look at to see if you've actually moved out, if you've turned over the keys. Also, providing a forwarding address is important because that goes to a security deposit. It's not your next, doesn't have to be where you live, just a place where you can receive mail. And the law on security deposits requires that the landlord send the deposit or the accounting statement to the last known address on file. Well, let's kind of think through what would happen if we don't provide anything. What is the last known address on file? It is the address that we all know we don't live at anymore because we just moved out of it. All right. So how long to return the security deposit? Law says 30 days, and in the lease, it could be extended up to 60 days. So your lease probably says 60 days. If your landlord does not return your deposit, you send a demand letter. I have certified there, but at this point, I would honestly recommend against it, especially if it's a PO box, because you're not going to get a signature. It's going to attempt service for 2 weeks. It's going to be returned to you. It was expensive and you paid for nothing. So send it via tracking. That way you have some proof of when it was delivered. Also, very important, keep a copy of the letter. In fact, anything that you give to your landlord, email, text message, something written down on a scrap of paper, keep a backup copy for your own records. It is very hard to prove something that you don't have. Landlord may return only part of the deposit. Be aware of any kind of restrictive endorsements, which say, you know, by signing this, this is a full and final settlement of any and all disputes relating to the security deposit for your tenancy at blank, blank, blank. Just be very mindful of that kind of language, right? If you don't receive a response to your demand, you can initiate a small claims action. If the amount we're talking about is under $7,500, if it's under $25,000, then you're in county court. If it's greater than $25,000, you are at a very expensive rental property. But you can seek treble damages if the action is filed within 1 year and a willful wrongful withholding is found by the court. If the landlord deliberately fails to return the security deposit during the additional 7-day period, the notice that you're providing, that demand that you're providing, is a 7-day letter saying you have 7 days to send me my money or I'm going to take legal action. Then the retention is logically willful under the section, and you have the case that comes from. Early lease termination. When's it possible? By the language of the lease, the breach of the warranty of habitability, like we went through, if protections for victim survivors of gender-based violence, military orders, acts of God, so long as you are not the God in question. Lightning strikes your apartment, lightning strikes your house, burns to the ground. That's it. That's an act of God. You put a pot on the stove and fall asleep, that is you. So that's going to be a problem for you. Don't do that. If there are repeat breaches of the warranty of habitability within a 6-month period. All right. This is the eviction process here. Landlords must resort to the court process. They cannot use self-help. We've gone through some of the reasons there. Mediation is required for certain tenants, and that's by a neutral third party with the purpose of assisting folks to try to settle the dispute outside of court. Mediation might result in a payment plan, supplemental rules for a tenancy, an extension of lease, something along those lines. Like I said earlier, SSI, SSDI, and cash assistance through Colorado Works. Commonly, we think of TANF, but there are other assistance there. The tenant discloses that in writing to the landlord. So if you receive SSI, SSDI, or cash assistance, it may just be best practice to let your landlord know that on if you're falling behind on rent, you know that, let him know right away. All right. Landlords are required to participate in mediation unless they're a nonprofit which offers residential tenants mediation prior to filing a residential eviction, or 5 or fewer single-family rental homes, and not more than 5 total units. Here is the process of mediation, the costs, and the scheduling. I'm just moving through this now. Again, go through it, get the slides to review these more. Mediation cannot be waived in a lease agreement. All right. So you receive a notice or a demand. Hey, there's the first page of the notice to terminate tenancy. Thanks for showing up on this slide, buddy. That's where they have to describe the property. The date of the termination of tenancy has to be signed by the landlord and must be served by statutory deadlines. This is more for a notice to quit at this point, because like we talked about, everything else is 90 days. Notice to quits still apply where the no fault doesn't. Right. So if it's, for example, a 6-month lease doesn't get a 90-day notice. That's going to get a 28-day notice. Yes, 28-day notice. A 3-month lease, 21-day notice prior to the end of the applicable tenancy period. So you get a demand for notice, for a demand for compliance, rent assistance application, contact the landlord to maybe work out a payment plan. If you are a victim survivor, put them on notice of that. If you receive SSI, SSDI, or cash assistance through Colorado Works, put them on written notice of that. That is not a phone call. That is a text message. It is really hard to prove what was said on the phone. It is very easy to prove what was said in a text message. It says it. For other violations, provide the land, if it's, let's say you have a dog when you're not supposed to, provide documentation that the dog was rehomed, or that, another violation has been cured. If we're talking about a substantial violation, if there's documentation showing you did not commit it, do that. Same with repeat violations. If it's a notice to quit, see if it complies with your lease. Contact your landlord to work for a lease extension, or prepare to move. So demands must contain a statement regarding the right to mediation, like we talked about. That is the exact statement there. So after we receive the demand, the next step, we're getting a summons and complaint. The summons, this is the language that must be contained within the summons until August 6th, when new language is required to be put in the summons. It also has to have a available list of resources. So if you ever get a summons there, you're going to find Colorado Legal Services contact information with it as well. There has to be a copy of a blank answer form, a request for documents form, and a mediation form / advisement. So that's what is required in a summons. It can be served personally or by posting. However, if a summons and complaint is served by posting and an answer is not filed by the tenant, then the landlord can only obtain a judgment for possession and not for unpaid rent. If you appear on your return date or file an answer into a case, you waive personal service. And at that point, a landlord is able to pursue monetary damages if they get an eviction. Okay. Here is kind of the state form or the JDF form for an answer. These are the legal reasons that you should not be evicted. The form has a lot of reasons. However, this is not the complete list of defenses. So if you're looking at it and you're saying, well, this happened, but it doesn't really fit neatly into any of these boxes, it may be a defense, and it doesn't really have to neatly fit into any of these boxes. Answers are due by 5 p.m. on the date of the return. Here in Colorado Springs, return dates are non-appearance. If you get a summons, it's going to say, so if you get a summons, it's going to say on this return date here, take non-appearance. It's going to say 8:30 a.m. non-appearance. It's going to be real confusing. All right. That's because in El Paso County here, we don't actually have in-person return dates. What needs to occur by 5 p.m. on that date is that either an answer is filed with the court, a motion is filed saying that a payment plan has been accepted, or some kind of other settlement's been filed with the court. Improper note, a defense alleging that the notice is improper must be raised in an answer or in a pretrial motion. You cannot raise the defense of improper notice for the first time at a hearing if it was not raised in an answer or a motion. Trials are supposed to be set 7 to 10 days after an answer is filed. And then between the filing of an answer and the trial, the court shall order the landlord or tenant provide any documentation relevant to the current action. If we are alleging warranty of habitability as a defense, those documents must be provided 96 hours before the hearing date. Also, if at any point between the service of the demand and a judge saying, I'm entering judgment for possession in favor of a landlord, as a tenant, you have the right to cure the non-payment by paying all amounts due under the lease. And at that time, the law would require that the case be dismissed. May pay the amount to your landlord, or if they refuse that amount, you can go to court and pay it to the court as well, and that would have the same legal effect. Once a court confirms that the full amount has been timely paid, vacate any judgments that have been issued, dismiss the action with prejudice. If your landlord does not follow the mediation requirements, that is a defense against an eviction. So again, make sure to appear at the return date, even if it is a non-appearance date, because action, or better yet, make sure that you take some kind of action, okay? I keep this slide in here because if you move to another county in Colorado, the rules are likely going to be different. So don't want you to move to Douglas County and go, well, I don't have to show up. I'll just do what that attorney told me. No. You need to call the courthouse to see what the rules are. All right. A writ of restitution. This is the end of the case. This is the end of your tenancy because at this point you have been evicted. All right. Writ of restitution is the document that allows law enforcement to remove you from the property and turn that property back over to your former landlord. They cannot be executed. So you cannot be removed until either 10 days or 30 days after a judgment for possession. All right, the writ can issue after 2 days, but it can't be used until 10 days. So if you get evicted, the worst case scenario after that eviction is that you're removed 10 days later. Illegal evictions. If you've been illegally evicted or excluded from a dwelling unit, you may have grounds for a lawsuit, and you recover further you're to try to stop further violations, recover damages, costs, and other attorney fees. You can seek actual damages and either 3 times the monthly rent or $5,000, whichever is higher. And you also can request an order for possession so you can move back into the place that you were illegally evicted from. Fair housing prohibits discrimination based on protected status. There are exceptions to fair housing. Income discrimination, can't discriminate against lawful and verifiable sources of income. Service animal versus emotional support animal. Real quick, service animal can only be a dog or a miniature horse. It is protected by the Americans with Disabilities Act. It is a medical device and not a pet. An emotional support animal is not protected by the Americans with Disabilities Act. And you must make a reasonable accommodation request first. All right. If it is an emotional support animal, you must get permission first. Right. Service animal is a same thing as a nebulizer. It's not a pet. Reasonable accommodation. This is if you require, like an emotional support animal, you have a disability and you do require a reasonable accommodation to the rules or regulations of the dwelling so you can have full use and enjoyment of the property. There's no magic language to make the request, but it must be in writing. You actually have to state what the accommodation is that you're looking for. An example beyond emotional support animals, let's say you have mobility issues and you can't make it from the back of the parking lot and you need a reserved space in the front. That would be or installing a grab bar in a shower. That would be a reasonable accommodation to an existing rule. Asking for a new elevator to be built probably isn't. All right. All right, the Mobile Home Park Act addresses additional rights for tenants in mobile home parks who own their homes. They require a written lease or rental agreement. Termination must be for cause, 90-day demands, 90-day notices, security deposits not greater than 1 month. Park management notice to enter a mobile home space requires 72 hours notice. These are the lease requirements for park cases. These are reasons that these are what constitutes cause for a mobile home park act. This is about rules and regulations. If you give permission, the rule can go into effect immediately. If you don't give permission for the rule, it goes into effect 60 days later. This is the park, a homeowner's right to privacy in the park, and the role of written consent. This is all about the Mobile Home Dispute Resolution Act. We are not going to cover any of this. This is an alternative dispute resolution for folks in a park. All right. And if the acronym, if you're trying to think of it, MHPOP, Mobile Home Park Oversight Program. I am just going through this so I could get to this slide and open this up for questions for the next about 15 minutes here, folks. So please, none in the chat. Yes. So sorry, I was. The question was, how much notice does your landlord have to provide you if they want to enter your residence for a non-emergency purpose? And I'm assuming that we are not talking about the Mobile Home Park Act. All right. There is not a specific law regarding that. All right. So terms of lease would likely apply. There's a general concept to think of here, and that is that as a tenant, you have the right to possess the property to the exclusion of others. All right. You don't own it, but you're the one that gets to be there. Okay. So as far as if we're dealing with the warranty of habitability, you give permission to enter. Right. But if it's, terms of your lease are probably going to control on that situation. Okay. And if your lease is blank, and it's probably one of those questions where I'm going to say, I don't have the answer. And you might if you should either contact CLS or Justice Center to try to figure that part out. Right. Sir, you had a question when you sat down. We ran through the eviction stuff pretty quickly. What questions did you have about that, sir?
adequate, the case should be terminated. And then for the end of the period of time that the rent was paid for, the landlord starts charging legal fees.
As far as whether or not that's proper, sir, I don't have that answer off the top of my head because I'd have to look through a few things like the court records and the prior lease agreement as well. But if you want to have it, that would be something where I would certainly say to this would be an issue where I would recommend trying to apply with Colorado Legal Services to see if either somebody in our housing unit or we also have attorneys that focus on consumer protections, if they would be able to take a look to see what was going on with that landlord, sir. That's just a little too specific for this evening. And also, the first thing I would want to do is read through your lease agreement and review the court records in the case to give you a more complete answer. So I'm unable to answer that question tonight as well, just because I don't have enough information. But that does raise some red flags for me. So that's why I would really recommend following up on that, sir.
Well, if you wanted to address that, the case is no longer active, would it make sense to do a motion for clarification? And if they served the 30-day notice,
Sir, I don't know.
You haven't paid the fee.
Mhm.
Like, how do you respond if the case is no longer active?
And that's why I don't have that answer, sir, for you right now, because there are options there, and I'm just not sure which option would be the best for you. So this is just not a question I have the ability to answer this evening. All right, just because it requires more work than I'm off the top of my head. Okay.
Two in the chat.
All right.
The
we-
first one's about a duplex.
Okay, we bought a duplex and the tenant came with it. Is there any way we could change the lease, or do we have to honor the previous owner, landlord, and lease agreement? Gabby, that's a little bit too specific for this evening, but as we were talking earlier about when ownership changes, that contract does travel to the new owner. All right, so but parties are free to contract at will, so you could try to enter into negotiations with the tenant, but the tenant does not have to negotiate with you. So another question in the chat, can a landlord have the lease convert to a month-to-month at the end of the term if a new lease isn't signed for an additional monthly amount, but still require a 45-day notice of intent to vacate? Defeats the purpose of month-to-month and paying extra for the privilege. Landlords are not so that's going to first question, can a landlord have the lease convert to month at the end of the term if a new lease isn't signed? Yes. For an additional monthly amount? Yes. Can they require a greater than 30-day notice of intent to vacate? Yes. They can require all of those things. However, damages for not providing a 30-day plus notice to vacate are limited to actual damages, not any kind of liquidated damages where they say, if you didn't give us this notice, then you agree to pay an extra 2 months rent. So that would be a situation where they can require that. But as far as the enforcement mechanism, I don't know how easily that would be able to be enforced, because they can only pursue actual damages at that point. But that's a really good question. Thank you. Any other questions, folks? So if we think of damage from a legal perspective, it's not it can be putting a hole in the wall, but it's not putting a hole in the wall. Damage means I'm out this amount of money. All right. So because you didn't give me that notice as required, I didn't have the time to hire a cleaning contractor, to hire a cleaning crew, to shampoo the carpets in a timely fashion, to get photographs taken, to put it up for advertisement, to do tours. And I got set back like 30, 20 days or something. So my damages would be this 20-day period where I was unable to have rental income because you gave me a notice that wasn't compliant. So that's when does that explanation kind of flesh that out a little bit more? Okay. Because that's what we're talking about when we're speaking about damages. It's kind of a lost opportunity, right? I lost money because I didn't have the opportunity to do this, right?
I'm sorry, that form?
Tenant portable screening report. Yeah, we do. Portable tenant screening report. The one we were talking about where you take it and you hand it to every landlord. Yeah, that's available. I don't know if you ask me, where do I get one? I don't know. Look it up. Okay. I'm also not here to give recommendations to specific companies because I don't know who does a good job. I'm not about to be on a recording with the city of Colorado Springs saying this company's great. I endorse them. Yeah. So that is available now. Just kind of searching for that portable tenant screening report. All right. Yes, sir. Yes, it is, sir. If you signed up for the registration, then it will be sent out. That's why I just felt okay skipping some slides and really speeding through some others because it is available. You just have to complete the registration and it will be emailed out to you. Question from the chat. Thank you, Gabby. If there was a dispute between the previous owner and tenant, are the new owners liable for anything? Gabby, you're really not going to like this answer, but it's a classic lawyer answer. Maybe. It depends. Sorry, I can't give you anything firmer than that just because it's going to depend on issue. It's going to depend on what the dispute is over. So I don't have that answer for you all just kind of as a snap judgment. Some instances, yes. Some instances, no.
Psychology students would say, yeah, maybe it is, and the business students are like, these are black and white. What is to? Where's your answer? I have another question.
Of course.
If you sued them and you won, you can still stay there for damages that they were liable for? It's the landlord. I forget what the question was.
Oh, the question was if there's a dispute between between the previous owner and the tenants, are the new owners liable? But to go to your question, is it possible to file a lawsuit against your landlord and remain in the property? Yes.
If you or win.
Win, yes.
Yes.
Okay, if you lose the eviction lawsuit, you're probably out. But think about the warranty of habitability. You can file a lawsuit for a breach of the warranty of habitability, but at no point is your tenancy really at risk. Okay, so yes, that is possible. It likely to be uncomfortable, but possible.
Mm-hmm.
All right, I've got another question from the chat. If a lease is signed with a requirement to do something during the time tenant occupies the premises, but then is not included at all in the new lease signed the following year, are those required? I don't know. So at this point, that one is just, I'm a little hesitant to answer that because of I don't want to accidentally provide legal advice because this is very specific. So I would need to read what it is that it's too vague and too specific at the same time. If you provide more details, I'll tell you we're asking for advice and to apply for CLS assistance, but this does really seem like a good type of advice question for you to ask. So I would recommend reaching out to CLS or again, reaching out to the Justice Center tomorrow night as well. Oh, of course. Thank you. That's a really good question, but I'd want to read the first question I have in response is I need to read the leases to see what we're talking about. And tonight's just not the night for that. Thank you for your question though. And thank you everybody for attending online. I really appreciate it. We're kind of closing in on 7:30. And I don't want to incur the wrath of the front desk again. I did that last time and I will not do that again. Does anybody have any last questions for me this evening? Yes, sir.
You have.
You're describing,
Discovery.
right, so you'd have to get a discovery order for depositions or for interrogatories or for admissions. I suppose there's,
Discovery order is what?
you would have to make that argument for it, sir. If we're in an eviction case, then the laws, there's not an explicit right to depositions. You have the ability to subpoena witnesses. But as far as kind of forcing a deposition before a hearing, there's not a right to that in an eviction context. If we're expanding to broader civil litigation, then we just get into broader civil discovery concepts. I don't have the snap judgment off the snap answer off the top of my head as it relates to depositions, but there's nothing in my mind that bars that prohibits that either. So the answer, I'm sorry for another lawyer answer here, is probably we just have to work to get to that point first. All right. And since we're talking about possible witnesses and a possible claim, there's a lot of moving pieces here. So it's hard for me to give an answer beyond maybe. And I'm sorry if that just seems pretty hollow, sir. Of course, of course. Yeah, of course. Great question. I don't know. All right. So how do you prove it? Words, actions, text messages, witnesses, I mean, behavior. It's not easy because it's tough to prove what's going on in here. Sometimes people say the quiet part out loud. If that happens, great. You know, like if, as an example, I reviewed a letter from a landlord previously in which the landlord concluded the letter with, "That's why owners don't like you voucher people, you're dishonest." That's not good language. If you call me up and ask me a question, sir, I'm going to tell you to apply online for CLS services. You can give me a call and I can direct you on how to apply. But the first step with CLS is to apply for services, all right? Because we assist folks that have gone through the application process. As the housing unit, we staff housing cases once a week on Thursdays. We're also over at the courthouse on Tuesday and Thursday mornings to assist up to 5 people with eviction returns. So we are constantly taking on new cases and new clients. So please, 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 apply to see if there's anything that we may be able to assist you with in this matter, sir. Okay. Huh? No, no fee to apply. We don't charge for legal services. We're a nonprofit. All right. I sure can. All right, I think I'm doing
Just
it double.
showing the folks in person, the maybe
Oh,
the
no.
thank you slide, which really just has a list of the organizations again and some of the services they
No,
provide.
I lost it.
I just want to ask you to join me in thanking Clinton for providing this great information.
Thank you all so much for coming tonight. I really appreciate it.
Deb Hamilton from the library who did most of the work making this happen. Thank you. And also the other agencies who are part of the collaboration and providing services. So yeah, be sure to make sure we have your email address and you will receive the video and the slides. We also will send out probably a link to a survey. I believe the survey is still up on the Justice Center's actually website, just to give us feedback on what was great, what you would suggest for improvement. And we have I think we have the November one scheduled, but not the summer. Or
The housing.
Oh, yeah,
That-
right.
yeah.
At least
That's what it was.
which is like bigger and better because it will have even more resources for folks. And we'll also be sharing those events that are coming up with you by email. So thank you again, everyone. Have a great evening.